just weight measuring that, right? You know,
No, I did. I don't think so. But most of my classes are actually, I use 7 hours.
pretty much what it's doing. Thesis or whatever.
You know, look at like. Is it? Yeah. Now I'm gonna do that. But you gotta pay like $50 to see who's that. Well, it's like read all the other.
Oh, you want to see two-sided.
All right.
I bet you could go on Pine online and find it. Pine online is gold. Really look for that stuff. Or sound like better. I hear something. All that matters is that the green. Nobody's gonna go.
Something that actually lost with is exact opposite. Project-based learning. Like, you could do just do everything with the last one. Pretty much everything that we, I just want to advocate how to be a teacher, but 90% of the people who lost it would be not supposed to. But then you have one for high school, junior high, high school.
Yeah, I think a lot of those supposed to be different. Supposedly, in theory.
We thought it would be
Okay.
Yeah, I think no. At all. Yeah, I think there's only. So, so if you let it speak, maybe we can get somewhere. Object every time you say a word. Put 2 words out. All right, dude.
I read directly from the book, the answer, exactly from the book. And he's like, oh, I'm like, it's right here. You said I.
It got to the point where people in my class stopped. We know the answer. And so he made everybody that was going to participate sit in the first 2 rows. Everybody else in this is like back 3 rows. And in the middle row, he put a framed thing saying, by sitting behind this, I recognize I will not be counted as present. Yeah, this is like right before COVID. And then that happened and we went online. We talk online. There's no Q&A, so it's just we talk actually. With no camera. No camera on. And he's just sitting there like.
Shall we get this show on the road? All right. Yeah. Well, welcome back, everybody. Hope you had a good spring break. And we've got Easter break coming up, right? Yeah. Is there not an Easter? There must be an Easter break. Am I mistaken? There's a 1-day Easter break. All right. Well, let's take what we can get, right? All right. So glad we got that. But hopefully you had a good break. You had some time to spend with friends or family or loved ones or things like that. I did my best to take advantage of the time. I had my annual physical. Yes. So apparently I'm alive and kicking. So that's a good thing. And I was very relieved to hear that probably thanks to Lent and fasting, I was 4 pounds shy of technically being obese, which I'm sure still means I still look obese, but at least when it comes to the body mass index and the 4 pounds that I've lost during Lent, which I'm sure I'll put back on once Lent is over. That's just how life goes. So I stand before you a fat man who is not technically obese. So proud of that. But I don't know, maybe I can let that inspire me, try to keep it off this time. We'll see. But hopefully your Lent is going equally as well, and hopefully I'll get even more out of Lent than just a loss of a few pounds, and hopefully the same will be true for you too. So that's one of the things I'll pray for you today. Also, I know you've had midterms in many of your classes. I'll pray that they all went well. We've got a graded paper coming up and a final exam coming up. I'll cover that in a minute when I get to the housekeeping slide, which I'm not quite there yet, but it's coming. So when we get to housekeeping, we'll cover that. But before we get this show on the road, you've always been kind enough to indulge me as I begin every class with a prayer. So let me do that again. As always, an optional part of the class, but a part that if you wish to participate in, then I will be doing more than just praying at you and praying for you. If you wish to participate, then I'll also be praying with you, which would flatter me greatly. And with that said, we pray in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto you, O Virgin of Virgins, my mother. To you do I come, before you I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in thy mercy hear and answer us. Amen. In the name of the Father, the Son, Holy Spirit. Amen. Thank you. And back to that housekeeping. As you know, we have a syllabus which it pays to read. Perhaps I myself should read it from time to time. When speaking off the cuff in our last lecture, I mentioned that the midterm exam that you'd already taken was worth 40% of your grade. And I thank those who brought to my attention that I misspoke. As the syllabus says, the midterm is worth 20% of your grade. The graded essay is worth 10% of your grade. And the final exam's the big one. That's worth 70% of your grade. That's in the syllabus that I wrote and probably should have read. And it's at the bottom of page 5, and it's approved by your law school. So it is the final word. I misspoke, but that misspeaking will not mean that we'll change what's on the syllabus. We'll follow the syllabus. So speaking of following the syllabus and continuing with our housekeeping theme, as you notice, we've had a nice little system where our first lecture covered chapter 1, and our second lecture covered chapter 2, and our third lecture covered chapter 3. But the syllabus kind of breaks that beautiful system in a way. We squeeze in chapter 8, chapter 9, and chapter 10. If you look again at the middle of page 5 of the syllabus, chapter 9 kind of overlaps chapter 10 overlaps chapter 11 in such a way that in 2 classes we cover 3 chapters. So for that reason, it might be a little hard to keep up with me for this lecture, the next lecture, and the lecture after that. But once we've managed to cover 3 chapters in 2 classes, after that, we're back to that slow and steady wins the race, where each class you can count on covering 1 chapter. So to the extent that you're willing to bear with me while we do that, I appreciate it. And that'll bring us out of housekeeping and into some actual material. And where we left off was chapter 8, which I summarized in a slide. There was a lot of material on that slide, so I'll make sure to upload that to the website. That's the last bit of housekeeping. I've been diligent so far about getting the slides on the website after the lecture, but then I heard that it was spring break, I had a week off, so I took a week off from that task too. So I'm behind on that, but I will catch up before we meet again, and the slides will be there. Likewise, you can watch any replay you want on YouTube at any time, but I'll add those links to our website, flaconstitution.com, next to the slides. So if you want an easy place to find them, you'll find them there. Yes, you had a question.
So in today's class, we're going to be covering chapter 8 and 9, is what you're saying?
8 and 9.
Okay.
We're doing fine by covering both 8 and 9. I threw in a rhyme, so I won't annoy you at this time. Okay. Or maybe that just adds salt to the wound. I don't know which. But to the extent that you'll bear with me while I squeeze in, like the syllabus does, an extra chapter, I appreciate it. So chapter 8 is great. It talks about how to amend Florida's Constitution. And you remember that slide that summarized it all. Like every other state, the key to knowing how to amend that state's constitution is found within the text of that state's constitution. Florida was no exception. And you saw that we covered various ways we can amend Florida's constitution. And all of those ways resulted in a proposal, whether it was from the Constitution Revision Commission or the Taxation Commission, whether it was from the population drafting and signing petitions, whether it was from the legislature, regardless of the source, that proposed amendment became a proposal. And regardless of the source, what then was required in order for that proposal to become an amendment? What was required was a vote of the people, regardless of the source of the proposal. Ultimately, that goes before the voters of the state of Florida, who then vote yes or no. And that's where we left off. Specifically, I guess we're roughly on page 256 of the printed word, if you're using the printed book, or it's chapter 8, subsection D as in dog, if you're using the ebook. Either way, we're talking about judicial review of proposed amendments and ballot summaries. And that brings us to our case of Densler versus Anstead. So as a opening or intro to that case, we talk about an enabling statute, specifically chapter 101 of the Florida statutes. And that talks about how the voting requirements of Article 5, Section 5 and 6 of Florida's Constitution are implemented. These enabling acts contain various requirements for the amendments that appear on the ballot. Most relevant to our discussion of Densler versus Anstead is the requirements for the ballot summary. Ballot summary. When the voters vote, don't they have right there in the ballot box the full text of the amendment upon which they are voting? No, they do not. What the voters have is a pre-approved ballot summary. Chapter 101 of the Florida statutes talks about how to get that pre-approval, and cases such as Densler versus Anstead show how the Supreme Court of Florida can be involved in litigation as to whether or not it is an adequate ballot summary. Turning now to the enabling statute in chapter 101, we see that there are specific requirements, not only for the ballot summary, but also for the title of the ballot summary. The title has a maximum length. The ballot summary itself has a maximum length. After the title and the ballot summary, the vote must be yes or no. Those are the two options you're allowed to have. And it must be written in such a way that when the voter votes yes, that indicates approval of the proposal. So that is roughly how it works. Densler versus Anstead gives us more rules of law that we can apply to whether or not a ballot summary is adequate. Now, this isn't the first time, if you've been paying attention, that we've encountered and studied the ballot summary in our lectures. Do you remember when we encountered and studied the ballot summary in a prior lecture? It was when we were talking about the canons of construction of Florida's Constitution. When we looked at those canons or rules of construction, one of those rules told us that we look to the intent of the framers or the voters to help us interpret the plain language of the Constitution. One of those sources of intent was this, the ballot summary, because that's what the voter said yes or no to. That was how the voter understood the amendment to the Constitution to operate. That was the legal effect that the voter was told that this amendment would have. And it is based upon that stated legal intent that the voter voted either yes or no. That's why when we studied the canons of construction, the ballot summary was a valid indicator, one of the valid indicators that could be used to determine the intent of the voter, which in turn could be used to determine the plain meaning of the plain text of the Constitution of the state of Florida. So when we look at these ballot summaries, there can be litigation over those, and Denzler versus Anstead describes such litigation. Over here, the Secretary of State is Ken Denzler. Hope I'm pronouncing Denzler. Never met the man. Don't mean to insult him by mispronouncing his name. I'll go with Detzner. Hope I get it right. So Ken Detzner was Secretary of State at the time. This is a 2018 case, about 3 years old. And he's seeking review of a circuit court of the Second Judicial Circuit and their ruling. What was their ruling? Their ruling was that this particular ballot amendment summary was insufficient. Now, what particular amendment are we talking about? In the case of Denzler versus Anstead, it is a ballot amendment that we encountered before, twice before. Once in our very first lecture, in the very first hour of this class. As you remember, until 2018, the Constitution of the state of Florida included within it discriminatory language that discriminated against our Asian American brothers and sisters by saying, prior to the amendment, that equal protection of the law protected everyone except, and that's not an exaggeration, the word except appeared in Florida's Constitution, except that the ownership, inheritance, sale of real property by aliens ineligible for citizenship could be regulated by Florida law. The phrase aliens ineligible for citizenship was a reference to our Asian American brothers and sisters. The Constitution was unconstitutional because the Constitution of the state of Florida attempted to allow discrimination based on race. How do we know that the text of the state's constitution was unconstitutional? Because it was a clear and blatant violation of the full panoply of federal constitutional rights, which include freedom from discrimination based upon our race. But yet the language was in the Constitution. And that language had been attempted to be removed before. Now in 2018, we see there's a challenge to the ballot summary that would put before the voters yet another chance to delete this discriminatory language from our state constitution. But before the voters can do that, this lawsuit has to result positively and allow that ballot summary to stay on the ballot. So now, what is the legal challenge going on here? One of them has to do with the fact that this particular proposal to amend the Constitution was combined with 3 other proposals, which I think when you look at them, you would agree were unrelated. And certainly the parties were arguing they were unrelated. In a later chapter, coming up in about a week or two, when we look at lawmaking and its limits, one of the things we'll find is that Florida's Constitution does not allow the Florida legislature or local governments to violate what is called the single subject rule. We'll study in those later classes some exceptions to the single subject rule, but suffice it to know for now that if the law addresses more than one subject, in other words, 2 or more unrelated subjects, that's an impermissible law. You got to divide them up. So the parties were arguing the same thing here. The Constitution Revision Commission had bundled 4 seemingly unrelated things and asked the voters to vote yes or no on the bundle. It's kind of like dealing with those pesky cable companies, right? All I want is internet. well, we're going to bundle that with your landline, or we're going to bundle that with your cell phone. We're going to bundle that with a cable TV package of 70,000 stations, some of which you'll literally never watch. And we're going to bundle that with a DVR made out of, I don't know, they're like 50 pounds. It must be like 1980s technology. And they're renting that to me like by the month, like it's a favor to have this thing taking up my entire living room, right? We've all seen the bundling before, right? And that's what the Constitutional Revision Commission is attempting successfully to do here. So the question then is that unconstitutional? And the Supreme Court of Florida holds that that is permissible. Their logic seems rather sound. I'll give it to you here. Oh, I lost it. I got to paraphrase it because I can't find it. Basically, they were saying, since the voters have the right to tear up one constitution and enact a totally new one, therefore the voters have the right to vote on a bundle. Because if you think about it, and I'm paraphrasing because I can't find the quote. If anybody finds the quote, let me know. It's a part of that power of the voters. If they were going to enact an entirely new constitution, it would be a long list of issues, some of which were unrelated to others. So if they can do that in the whole, says the logic of the majority opinion here, then they can do that in part. They can vote on a bundle. One of the arguments made was a violation of freedom of speech, and it appears to have been phrased as a violation of the federal freedom of speech, but I guess could also be interpreted in this case to have been an argument on the state constitution's freedom of speech, to which the majority rejects in whole cloth, saying you had nothing even to cite to for this alleged violation of freedom of speech. We find nothing either, and therefore we reject that argument, that novel argument of yours, that voters have a free speech, freedom of speech right to break it down into unrelated topics and vote on them one by one. So ultimately, all the arguments failed. The bundle was allowed to be placed before the voters, and the voters voted yes. So now that discriminatory language that until 2018 existed in Article 1 on the first page of Florida's Constitution is finally deleted by the voters. Of course, we're left with the question, was that the main motivation of the voters? You know, when you buy the bundle from the cable company because you wanted the internet, and you end up with this landline and this 1980s DVR taking up your living room, were you really motivated to get a landline? Did you really want to fill your living room with this hard drive that's clunking day and night to record shows? Or did you just really want the internet and you were stuck with the bundle, you know? So I'm proud, and I know you are too, as a Floridian, to know that this discriminatory language is finally removed from our Constitution. But of course, we're left with that doubt as to whether the motivation was pure. So that's one disadvantage. And as we move on in our class and look at the single subject rule as it applies to lawmaking, not to constitutional amendments, but to lawmaking, we'll look at other issues such as log rolling, such as buying votes and things of that nature. But I'll put a pin in that and leave that discussion for later. Instead, I'll turn to the dissent and the notes and questions to consider that talk about the dissent of this case of Densler versus Anstead. Page 261 on paper, very last page of chapter 8 if you're in the ebook, are the notes and questions to consider. Note 1, the dissent laments the majority's decision because, in the dissent's opinion, the majority does not honor the fact that the ultimate authority to amend the Constitution rests with the voters in this state. But is the dissent correct? What do you think? Is one way to look at the ruling of Densler versus Anstead? Is one way to look at it to say that ultimately the voters don't have the final say? Well, you might argue either way. What if you want to argue, no, that's That's not the outcome here. To make that argument, I would look at some of the things that this opinion cites to as rules of law and therefore upholds as rules of law. For example, it says here that in order for a ballot summary to be adequate, it's got to meet certain standards, right? It says here, the requirement that ballot language accurately represent the main legal effect and ramifications of a proposed amendment. So it gives us that rule of law from a prior case and reaffirms it here in 2018. Quote, in other words, the summary clearly communicates what it is that voters are being asked to approve or reject, and Florida law does not require that it do more than that, quote. It then cites with approval to a 1984 case that explains that the ballot summary should tell the voter, quote, the legal effect of the amendment and no more, quote. Cites with approval a 1982 case that states that the ballot summary must, quote, advise the voter sufficiently to enable him intelligently to cast his ballot, quote. And then finally, in his long list of citations, cites to a 2010 Supreme Court of Florida case that holds or upholds a proposed amendment and concludes that it was not misleading where the ballot summary did not disclose the amendment's specific financial impact. So we do have some hard and fast rules, do we not? First, a ballot summary cannot be misleading. Second, a ballot summary can be that. It can be a summary, and a summary by its very nature is incomplete. If it was complete, it would be a verbatim recitation. It's not, it's a summary. So by its very nature, it omits certain details. But it can. And by omitting certain details, it is not unconstitutional under Florida's Constitution. What it has to do is give an accurate description of what the proposed amendment will do. Stated more specifically, it has to accurately represent the main legal effects and ramifications. And to bring that full circle, because what the voters voted on in the summary was an accurate legal representation of the effects and ramifications of the full text of the amendment, therefore the voter summary is a fair place to go to try to determine the intent of the voters in enacting that amendment. You've got a question?
Yeah, I guess I read the dissent a little different. I thought that their main contention was that by making them vote either all or nothing on these three, as opposed to which one they selectively, individually agreed with, took the vote out of their hands, because while they would vote for A to be passed, they won't vote for A to be passed because they don't want B and C to be passed. So it invites voter manipulation in that regard.
Yeah. And tell me your opinion now. Is that a good thing that the voters should have to buy the whole bundle?
No,
Why not?
because amending Florida's Constitution is in the hands of the voters.
Yeah.
And so it shouldn't be taken out of their hands.
Yeah. And I guess that's the point of view of the dissent also, isn't it?
Yeah, I sort of agree with this.
Yeah. So now, is this case an example of the ends justify the means? We had before the voters in the past the ability to vote yes or no, not in a bundle, just straight up yes or no as to whether to remove the discriminatory language from Florida's Constitution. They voted no. They voted leave it in there. It hasn't shown up on a ballot again since that 1992, I believe it was, attempt. Every year there's amendments proposed. Every voting cycle, they're there. But for more than a decade, it never showed up. The people have the ability to draft petitions. None of them succeeded. Don't for a minute think that there weren't publicly active groups trying to get it changed. I don't know how to pronounce the abbreviation GOAABA, GOABA perhaps? I believe it stands for Greater Orlando Asian American Bar Association. I don't know if their website is still up or if they took it down after 2018. Use the Wayback Machine if they did. But you can see their advocacy for trying to remove this discriminatory language from Florida's Constitution. I was at an Orange County Bar Association meeting where a GOABA, if I'm pronouncing that abbreviation right, GOAABA representative talked to the room about the importance of trying to get this passed. So somebody took what many, I myself included, considered a noble goal and bundled it together to try to make it more appealing. Is the outcome, the ruling in Denzer versus Anstead, an example of judicial activism? Is it an example of the ends justify the means? Did this court simply not want to shoot down an attempt to get one of those four things before the voters, even though it was bundled with three other things as a four-pack, a bundle for them to vote for?
Seems
What do
like
you think?
favorable facts for bad law.
Favorable
I mean,
facts for bad law. you
Yeah, I
think?
mean, yeah, did they do something good here? Yes. But next year, how could this be used to,
Yeah.
if there's maybe it's flip the situation and make one law that all the citizens really want to get passed and amended into the Constitution.
They're
Sorry.
dying for it. They're
Amended
craving
that
for it. They
want,
want
but it
that one.
it screws up taxes for the government on some other end. And so they bundle it with a bunch of other laws that they know, a bunch of amendments that they know aren't going to get passed.
Yeah. Yeah.
So I feel like it can be used as a weapon more than a benefit. I don't see this being used like in a good way in the future. I see this being used as in a bad way by the government in the future.
You see danger ahead.
Yeah, this doesn't look friendly to me.
Anybody disagree? You disagree or want to make another point?
Another point.
Another point. Make another point. Go ahead.
I was gonna say, maybe I missed in the reading, with the bundling, is there any way to do like a line item veto?
No, because keep in mind physically what's going on here. It's you and me. It's we Floridians. We're at the ballot box. And typically, I don't know, maybe you're at the ballot box to amend Florida's Constitution, but I would guess that you might be in the minority. Typically, you're there because you're voting on the president. You're voting on the governor. You're voting on the mayor. And along with that is the Commissioner of Agriculture, the second seat on the school board, the third position in the water management district, and a bunch of proposed amendments to Florida's Constitution. So if you're like most voters, I'm guessing you were there for another purpose, but you've got these other things to vote on too. So I think that's what's typically going on. Do you think so?
I also don't get the argument on how it is beneficial in any way to not just allow them to vote on each individual amendment. I don't see how that benefits anybody.
Yeah, maybe it doesn't benefit, but you picture you're in the ballot box, and do you have that line item veto? Can you?
No.
Can you just take your pen and bubble the Scantron, yes or no, A or B, or can you cross out the amendment and highlight this and write down how you want that to happen? No, right? You can't do that. Closest thing you have to that is occasionally you can put a write-in candidate. Occasionally. Voted for my buddy's father once as a write-in candidate. He didn't win. Turns out he had passed away before I voted for him. Wish I'd known that. Probably why I didn't win. But anyway, putting that joke aside, you don't really get to write on the ballot, right? You just get to mark yes or no. So yeah, for all practical intents and purposes, there isn't a line item veto for we the people, right? So, note 2, does Florida Supreme Court have sufficient safeguards and rules to follow to assure that it is not arbitrary or subjective in its decision as to what proposals make the ballot? And again, that's a matter of opinion, but to properly express that opinion, you want to go back to the rule of law that we learned about whether a balanced summary is sufficient. What are those rules of law? Let's try to sum them up. First, you have the technical requirements from Chapter 101, right? Florida Statute Chapter 101 was the Enabling Act that allows these ballots to be written. That had a maximum length for the title, that had a maximum length for the ballot summary, that had a statutory requirement that it not be misleading. Also, we have case law precedent to tell us whether or not it's misleading. That case law precedent asks us to look whether the summary put before the voters accurately tells them the legal effect of the full amendment. So we analyze the summary not only for its length requirements, but for the substance, for its substantive worth, with the question being, did it give the proper legal effect of the full amendment? Now, one easy solution for this is, if you're going to be an activist, if you're going to draft amendments to Florida's Constitution, and don't sell yourself short. In our state and in so many others, you have that right. You can draft it, you can get the petition going, get enough signatures, it'll get on the ballot. Draft the amendment itself with concise language so that putting the entire amendment before the voter meets the maximum length requirements of Chapter 101. If you do that, and you got a verbatim summary that matches verbatim the actual amendment, is anybody going to succeed in litigation saying, oh, that summary doesn't accurately reflect the amendment? It is the amendment, right? So you can solve this problem. You can foresee this litigation, and you can avoid this litigation. Through what? Through what every lawyer should strive for, through concise and accurate drafting, right? So that ends Chapter 8. Any Chapter 8 questions before we move on to Chapter 9? Yes?
You said you're going to post a slide of the beginning of Chapter 8?
Oh, yeah. At the end of our last lecture, which wasn't last week, it was 2 weeks ago, I summarized Chapter 8 as to how to amend the Constitution. And typically I post those slides within 72 hours, or at least that's my personal goal. It's not anybody's requirement imposed upon me. I imposed the requirement upon myself. And I failed to meet my own self-imposed requirements because I had last week off, and I decided, I didn't meet my own requirement. But I will turn those into a PDF like I always do after the lecture, and I'll post them on flaconstitution.com where you can see them there. Yeah, sorry I'm behind. I got lazy. So, yeah. Any other questions about Chapter 8 before we move on to Chapter 9? And we always take a break somewhere in the lecture. This seems like a logical place to do that. So I got on that clock in the back. Does it match the clock in the front? Clock in the back's 2 minutes faster than the clock in the front. Clock in the back says 6:20. Let's reconvene at 6:30. Not the 6:30 on the clock in the back, but the 6:30 on the clock in the front. So that'll give you 12 minutes instead of 10. Sound good? All right, see you in 12 minutes. Thank you. Gotta be warmer out there, man. Maybe I should throw the doors open.
It'll probably kick in more in here.
Oh, then the air will kick up more.
Yeah.
And defeat my goal. Okay. Yeah. was reminded of the importance of taking a break because I had to sit through a training class for something I already knew how to do today. All the federal district courts, they all use the same case management, electronic case filing system. But they're all in charge of their own, even though the software is literally the same. So even though I file regularly in the middle district here in Orlando, I don't have a logging code in the southern district. So they don't care that they're practicing for 25 years. I gotta sit through the 2.5 hour class.
Because they want you to pay for it.
Yeah, there's that. And the whole class, it was painful. Because it was a Zoom where they pulled up the website that I've been using for 25 years and then clicking on the same stuff I've been clicking on all these years and telling me, don't forget to click this. And it's just, but the most painful part from 9 to 12:10, it's supposed to end at noon, was no one took a break until 11:40. And then he acted like he's doing us a favor with 10 minutes. So I thought to myself, this is what y'all feel like when I just run the mouth and I don't take a break. So it's a valuable thing to learn like this. Wish I could have learned it the easy way instead of the hard one. So should a lecture like this, 2 hours long, have 2 breaks?
Sorry?
Should a lecture like this, 2 hours long, should have 2 breaks?
No.
Usually professors don't even get one
See, the norm is 0 breaks?
for a 2 hour class, I think.
Depends on the
3
professor.
hour class.
Okay, huh, all right. That's
But
nice.
we appreciate the breaks that you.
Yeah, no, I'm not gonna quit. Not gonna quit with the breaks.
But,
Not gonna quit. Yeah.
Tell them that.
So there's some classes that are 3 hours long.
In the
Yeah.
summer, they'll have the 3 hour classes. Or
Oh,
in the fall right now, I have motions and depots from 9 a.m. to 12.
Yeah.
so you're talking about motions and depots for 3 hours a day?
But
Wow.
yeah,
Is
basically
it
a
like
practice class.
oh, you gotta like draft them?
It's
Right.
a lot of presenting,
Well,
too.
presenting.
Oh,
And
okay.
everybody goes around and does their presentation.
Oh, okay.
That takes a lot of
I
time.
kinda like that. Yeah.
And my trial lab is 3 hours.
Right.
Yeah, for the same thing.
Oh, okay. And that one you get to like
Oh, yeah.
do some practical work. I like that. I didn't get a lot of practical work or drills or experience in law school. So.
Yeah, and that, I mean, if it wasn't for moot court, I wouldn't either. But
Yeah, see, I did that. I did new core. So guess I was craving. I was craving.
Yeah.
I was craving for someone to teach me how to practice law. Thought that was going to be in my law school curriculum.
Yeah, you would think.
Right?
I don't know if we gotta go out and do that on top of it.
Yeah. Figure that out on your own.
Do something extra.
The part problem is there's not enough credit hours left to do that.
Right.
Because you got classes like this one,
And then if you have a
which should
job,
not be
too.
required. And if they are required, it should be 1 hour instead of 2 credit hours.
And then if you work on top of it,
Yeah.
you really don't have any time.
There's still some classes that I wanted to say I'm 3 hours graduated, and I'm like, there's still a couple classes that I would like to learn before I leave.
Yeah.
Entire
Motions
school
and
forever.
deadlines. I didn't take motions and deadlines.
And you're a 302?
Yeah, it was my last semester.
Wow. Okay, so I guess you won't get it.
No, I'm
Yeah.
not getting it.
That stinks.
It is what it is.
Yeah.
Just couldn't fit it in. I was planning on doing it this semester. Already got 6 classes this semester, so not happening.
Yeah. What can you do?
No.
Well, when you get out there and practice, just find somebody else's motion for that same thing that succeeded.
That's what I think.
Swap out the facts of your case.
Pretty much what I do now.
And go from there.
Don't rework the wheel.
Right.
Reinvent the wheel.
No, there's not a lot of the law that involves reinventing the wheel. That's true. Yeah. So there's far more law that involves finding out exactly the right procedure to follow.
It's all public record. Go
Yeah.
find on Westlaw, even the case we were talking about last class, but the fifth, found suit in the fifth action.
Yeah.
I
Yeah.
just went to the main case on Westlaw from the Florida Supreme Court, pulled the complaint from that case, pretty much ripped it off.
There you
But
go.
they can't complain. Right?
That's smart,
You
man.
approved this complaint.
Yeah. No, that's smart. That's smart.
Can't say anything.
Oh.
Yes, it's not much.
It's not.
Sorry. I thought the weather report's gonna be hot today. Yeah. AC. No win-win situation. It's a lose-lose. But it's not like some of the other places in the country that are always saying, northeast, Colorado, so you get direct, 2 foot of snow. Not even the rocky area, it's the part that, like, the flat north part, Nebraska, Wyoming.
Yeah, so stop complaining.
Oh, I don't,
Before,
I'm not gonna, I moved here for a reason. I despise the cold. The military sent me to extreme cold weather training twice.
where?
First one, no, I was in Maine. Maine was for the first one, not even the second one. The first one was, I went to Japan, trained with the Japanese Ground Defense Force. In North Island, Hokkaido.
Oh, out in the mountain. Yeah.
It's up in the mountains. But there, I don't know, that portrait,
Geographic perspective.
it was awesome. But it
Yeah, no, I think
Welcome back. I hope you enjoyed chapter 8. And now we move on to chapter 9. And chapter 9 is part of a series, so just so you can see where we're going. Chapter 9, in no small way, is an introduction to Florida municipal law. But also, the way I use chapter 9 is also an introduction to the next 3 chapters. Chapter 10, we're going to talk about the legislative power. In chapter 11, we'll talk about the executive power. And in chapter 12, we'll talk about the judicial power that exists under Florida's Constitution. Now, the reason I put chapter 9 in Florida municipal law and the introduction to municipal law in front of chapter 10, legislative power, is because you'll note that under Florida's Constitution, as is true in the constitutions of every other state with which I'm familiar, more than just Florida's legislature has lawmaking power. Sometimes that comes as a surprise to the non-lawyer, probably comes as no surprise to you. But in order to properly cover the legislative power in chapter 10, we're first going to have at least a basic understanding of Florida municipal law and sub-state entities. So that's why we begin with local government, chapter 9. So I pose this question to you. Why do local governments exist? And sometimes we impose labels upon ourselves. I try not to put too many labels upon myself. But if I was going to put a label on myself, I probably wouldn't pick globalist. I don't often advocate a global point of view. As you know, one of the themes that runs through all of my works, including this one that you're studying here, is that Catholic social teaching idea of subsidiarity. And subsidiarity rejects the notion that all decisions should be made at the highest level. Indeed, subsidiarity argues, and I believe, that there should be respect for lower levels of society. Sometimes questions of public policy and the needs of the population are best met not by the highest government order, but sometimes met by a lower government order. Here in our federal republic and our United States democracy, we have states, and those states have rights. Within the states, we have other sovereigns, and those other sovereigns have rights. Subsidiarity tells us that the proper role of the highest government entity is to allow some delegation as appropriate to these lower governmental entities. In a way, that's the opposite of a globalist approach. Maybe you might call that localism if you're insisting on putting labels on things. So maybe what we're talking about here is localism. Why do local governments exist? Is it not possible for us to just here in the United States or in any other country to simply have one all-powerful federal government that imposes all laws and meets all obligations, enforces all laws and creates them all? Is that not possible?
It is possible.
It is.
The founding fathers were kind of getting away from that.
They were.
Yeah, they wanted something a bit different, more subsidiary.
Yeah, I see what you see. I see elements of subsidiarity, maybe not labeled as such by name, but I see it in our federal republic. I see it in our national constitution. Indeed, we look at some constitutions and we see subsidiarity mentioned by name. The European Union, the EU, for example, we see subsidiarity specifically mentioned there. And maybe we don't see it by name in our federal constitution here in the USA, but certainly I think the argument can be made that the concept is there. So why do local governments exist? And that's how I begin chapter 9. I talk about how the authority of the state of Florida geographically overlaps the authority of Florida's counties, cities, and municipalities. We'll define county and municipality with greater legal precision as this chapter continues. But all of Florida's potable water resources and designated activities of persons and companies that affect those resources are regulated by 5 regional water authorities. They geographically overlap with and cross the borders of Florida's counties, cities, and municipalities. So as I stand here today in Orange County in the state of Florida, I'm also within the jurisdiction of the Southwest Florida Water Management District. Various utility commissions regulate various persons, counties, cities, and municipalities within the concerns of the commission's activities in providing utilities. So I'm within their jurisdiction also. The Florida legislature from time to time has created various compacts. What's a compact? A compact is a specific type of contract. A compact is a contract between sovereigns. Perhaps it's 2 states, perhaps it's 2 counties, perhaps it's 2 cities, perhaps it's a county and a city. Perhaps it's a state and a county. If the parties to the contract are both sovereigns, we properly label that contract a compact. The Florida legislature from time to time has created various compacts and empowered the agencies governing those compacts to impose fees or otherwise exercise jurisdiction over Floridians and their counties, cities, municipalities, and unincorporated areas. So we see the power of lawmaking and the jurisdiction of many subnational entities that are in many ways sovereign with overlapping jurisdiction. And that's what we're talking about. But why do these things exist? Why do it? They have advantages and disadvantages, certainly. But they exist because our democratic republic allows for it. We're allowed to do that. How can local governments exist? How is it that they're allowed to do that? And that brings us to this question, which I posed to you in our first lecture, and I return to time and time again. In light of the supremacy, and let's not underestimate the supremacy of the Florida Constitution. I'm sorry. Let's not underestimate the supremacy of the federal Constitution. We know that by joining the Union and being a U.S. state, part of the federal Constitution is that supremacy clause, right? In light of the supremacy of the federal Constitution, what rights do states hold to create and regulate local governments? How can they even do that? How can they do that? Let's take a look for that answer at the first case in our chapter, Hunter versus City of Pittsburgh. This is a 1907. That's old. 1907 SCOTUS opinion, Supreme Court of the United States. But it's still good law. And it's as true today as it was then. What was at issue in this case? The plaintiffs in error, how's that for some prior century language? The plaintiffs in error seek reversal of the judgment of the Supreme Court of Pennsylvania, which affirmed a decree of the lower court directing the consolidation of the cities of Pittsburgh and Allegheny. These citizens were alleging that their federal constitutional rights were being violated by the consolidation of these two cities. Is it foreseeable that there could be human rights at issue when it comes to consolidating two cities? Yes, obviously there can be. So, under what amendment in the Bill of Rights of the federal Constitution is Hunter versus City of Pittsburgh based? Upon what federal right was the outcome of Hunter versus City of Pittsburgh? What part of the full panoply of federal constitutional rights dictated the outcome of Hunter versus City of Pittsburgh? And the answer is none. None. Quite the contrary. You see words like this in the holding. Municipal corporations are political subdivisions of the state, given the power to acquire, hold, and manage personal and real property. The powers conferred upon these corporations rest in the absolute discretion of who? Of the state, says the Supreme Court of the United States. To whom do we appeal when we don't like the outcome of the Supreme Court of the United States ruling? Nobody, right? Here it is, literally the highest court in the land saying that the powers conferred upon municipal corporations, counties, cities, towns, hamlets, villages are whose? They're within the absolute discretion of the state. Yes.
So why is it that there's a big, like on certain parts of states want to secede from a state, to create another state within a state?
You visited Key West, I guess, and there are ongoing tourist-driven conch republic wanting to secede from Florida. Is that what you're talking about?
I just saw that, I know there's the greater Idaho movement in places like the state of Jackson, Northern California,
Texas,
and also parts of Colorado. There are different counties that say either they want to just incorporate into another state, or become their own state, or separate themselves from the state.
Okay, thank you for telling me about that. It's just like the conch republic wanting Key West to be its own state or nation or whatever they joke about for the tourists. But you're talking about some actual regions of the country that aren't joking.
Yeah.
Okay, so what would answer that question? What part of the federal Constitution would tell us whether those not joking regions could break off and be a city or be a county or even be a state?
It would have to be, according to this one, it'd be the state itself.
Yeah, when it comes to whether or not you join the union, that's a federal question. So whether or not you become a state, Puerto Rico, whether or not you become a state, Guam, whether or not you become a state in Mauritania Islands, whether or not you become a state, District of Columbia, whether or not any other territory becomes a state, that's a question for Congress, right? That's a federal question. But whether or not you become a city, whether or not you become a county, whether you're incorporated or unincorporated or disincorporated, that's a question for state law. And why is that? Because the highest federal source says, quote, it rests in the absolute discretion of the state, end quote. That's why it's a state question. It's not a state question because the state said it's a state question. We studied that in chapter 1. If the state says it's a state question, who can beat the state? You were our scorekeeper, remember? It was what, 13-0. No matter how low a federal authority it was a higher authority than the state's highest source of law, the state's constitution, right? So now what we have is a federal source of authority. A federal source says that it, quote, rests in the absolute discretion of the state because a federal source said those words. That's what makes those words true. That's what makes those words enforceable. In addition to those words, we see that the holding is neither their charters nor any law conferring governmental powers or vesting in them property to be used for governmental purposes or authorizing them to hold or manage such property or exempting them from taxation upon it. None of those things is controlled by the federal Constitution. The highest court in America, certainly the highest federal court, the highest court in our land, says it's not a question of the federal Constitution. So that's how we can have these various local entities have lawmaking power and authority over us as citizens. That's how. So to answer the question, how can they exist? Because SCOTUS said they can exist. They said it in 1907. They haven't contradicted themselves since. In light of the supremacy of the federal Constitution, what rights do states hold to create and regulate local governments? They hold the absolute right because that which is supreme, the federal Constitution, gave them and delegated to them that right. That's the source of authority for local law. Source of authority for local law is federal law. Get it? Another quote from Hunter that may help you. This 1907 decision from the Supreme Court of the United States. Thus, the Supreme Court of the United States holds that a state, quote, at its pleasure may modify or withdraw all such powers. In all these respects, the state is supreme and its legislative body, conforming its action to what? The state constitution. The state constitution may do so as it will, unrestrained by any provision of the Constitution of the United States. Look at this quote, understand this quote. In light of this quote, answer this question for me. Can municipal law be unconstitutional? Yes or no? Yes, it can be unconstitutional primarily with reference to this Constitution, not primarily with reference to that Constitution. Does this make it impossible for state constitutional law to violate the federal Constitution? And the answer is no, it doesn't make it impossible. We still, as citizens of a state, or if you want to call it citizenship of a county, or if you want to call it citizenship of a city, still have our full panoply of federal constitutional rights. As an individual, you don't get to violate any of the full panoply of federal constitutional rights simply because you are a county or a city or the employee of a county or a city. And as our studies progress, we will look after chapters 9, 10, 11, and 12, specifically at certain concepts. And we will see how states and counties can be held liable for violating human rights of a citizen that are found within the full panoply of federal constitutional rights. So I'm not saying with Hunter versus City of Pittsburgh that you lose your human rights found in the full panoply of federal constitutional rights if the violator is a municipality or a municipal corporation or a county or a city. I'm not saying that. As to whether or not you create a county, as to whether or not you merge two counties, as to whether or not this petition for incorporation is granted and this becomes a city, as to whether or not cities can own certain things. These are questions to which the Supreme Court of the United States holds that at its pleasure, the state may modify or withdraw all such powers. Hunter versus City of Pittsburgh was litigation as to whether these two cities could be combined. Hunter versus City of Pittsburgh was talking about municipal powers and powers of municipalities. Remember some of the powers that were discussed. Some of the powers had to do, these governmental powers had to do with acquiring, holding, and managing personal and real property. These are the functions of municipal governments. Hunter versus City of Pittsburgh says those powers are within the absolute discretion of the state. What the municipal governments can and can't own, what they can or can't manage, whether they exist or continue to exist, their boundaries, their lawmaking abilities. These are the powers of municipal law that Hunter versus City of Pittsburgh puts in the absolute discretion of the state. But that's not the same as saying that a county or a city can violate your human rights as found in the full panoply of federal constitutional law. Don't conflate the two. Understand what I'm saying? Okay. Notes and questions to consider. If you're on paper, we're on page 266. If you're in the ebook, we're in chapter 9, part B, at the end of part B. I'm going to take these out of order a little bit, which is odd because I wrote the book and I wrote the lecture, and the two don't match. It's weird, right? Anyway, let me take them out of order. Note 4. Imagine the people of the state of Florida amend Florida's constitution. You know how to do that now, right? That was chapter 8. And pursuant to that amendment, the legislature of the state of Florida passes a law dissolving Florida's current counties, dividing the state into new counties, and distributing the assets of the former counties to the new counties. Wow. Redraw the map and literally take away not only property rights, real property, but chattel, right? The cars, the buildings, the assets, the bank accounts, the vehicles, the equipment. What rights would the old counties hold under Hunter versus City of Pittsburgh to challenge this as a violation of federal constitutional rights? If you're holding up to 0, nada, nothing. Who agrees? Raise your hand if you agree. If you want to be right, you want to get this question right, go ahead, raise your hand. Yes, you are correct, sir. Well done. That's the whole point of Hunter versus City of Pittsburgh. It was all in the absolute discretion of the state, right? So this hypothetical I spelled out here in note 4, there's no federal constitutional relief under Hunter versus City of Pittsburgh, right? Let's look at note 5. Imagine a group of neighbors would like their neighborhood to be its own city, but the state of Florida will not allow it. What federal constitutional rights, if any, might be violated? You held it up last time. Yeah, you held it up again. You're saying none? Saying none? Who wants to agree with that answer? Raise your hand if you agree with that. Come on, if you want to be right, raise your hand. Yes, none. That was the point of Hunter versus City of Pittsburgh. Again, hypothetical 5 is still have not trampled over any individual human rights that are protected by the full panoply of federal constitutional law. I'm still talking about municipal rights, municipal law, the rights of municipalities, right? Where are their rights? Their rights are within the sole discretion of the state, right? According to Hunter versus City of Pittsburgh. Okay, so that was notes 4 and 5. I'm not going to neglect to cover notes 1, 2, and 3. I'm going to cover them also. But you'll note that notes 1, 2, and 3, which are very much worth reading, introduce some vocabulary and some basic concepts of municipal law. So let me pull some sentences out of there, pull some ideas out of there, pull some vocabulary words out of there. Let me cover those 3 notes in this way. Let's talk about charter counties. Okay. Let's talk about non-charter counties. Let's talk about other municipal corporations other than counties. Let's talk about what's an ordinance versus what's a resolution. But first, beginning with charter counties and non-charter counties, got some more slides with some more details. But first, get ready, try to keep up as I give you a rough definition of the difference between a charter county and a non-charter county. We'll go over this as many times as you need to. The charter county has a charter. The non-charter county does not have a charter. What, McGinley? What? Slow down. Okay. The one with the charter was the charter county. That's right. The one without the charter was the non-charter county. Hey, if the class stays at this level, it's going to be a breeze of a semester, isn't it? All right. But let's back up a bit. What's a charter? What's a charter? Is a charter a constitution? No, a charter is not a constitution. Charters and constitutions are not the same. But by analogy, we might see some similarities between a charter and a constitution. I say that because a constitution can be a source of organic law. Likewise, a charter can be a source of organic law for the county. I say that because a constitution might spell out a form of government. Likewise, charter can spell out a form of county government. I say that because a constitution can be a source of the structure of government. Is it a bicameral legislature? Is there a separate court system? Can you appeal from one court to another? Which court is the highest? Constitutions certainly tell us that. Likewise, a charter can do the same. What's the name of our executives? We know that the Constitution tells us to call our president, not chief or cool. Likewise, the charter will tell us whether our chief executive is the mayor or the county chairman or some other title. So that's what a charter is. Must a county have a charter? No. But a county can get together, draft one, offer it to the citizenry, and then offer it to the Florida legislature, and the citizenry and the legislature might approve. And therefore, the non-charter county becomes a charter county. Charter counties and non-charter counties, therefore, are different because one is a charter and one doesn't. Here's the text of Florida Constitution, Article 8. I know I'm not supposed to look at the text of the Constitution in a constitutional law class. Don't tell on me. I mean, I could get run out of the whole nation, I guess, right? Anyway, if we look at the text of Florida's Constitution, we look at Article 8, we look at subsection G, talks about charter government, tells us the counties operating under county charters shall have all powers of local self-government not inconsistent with the applicable charter. Okay? Compare that now to what this same Article 8 says about non-charter government. That's subsection F. Counties not operating under county charters shall have such power of self-government as is provided by law. Okay, makes sense, right? If you didn't take the time and the voters and the legislature didn't approve you of having a charter, then you don't have that organic source of law that a charter provides. You'll just have whatever rights and authorities and abilities that general law provides to you, right? So what we see here is the non-charter county can do whatever the law says it can do. That roughly paraphrases the first part, right? What we also see is that a charter county can do anything unless the law says they can't do it. That roughly paraphrases that part, right? So the question then is, what's the difference, right? This one can do anything that the law says it can do. This one can do anything unless the law says it can't do it. But there can be a difference. There can be a difference. Let's see if we can find it. Question: can a non-charter county enact a law saying something is a crime? This is not the United States of America saying that it's a crime. This is not the state of Florida saying it's a crime. This is X County, Orange County, Osceola County, Miami-Dade County, Pickett County, Pinellas County. Can they take away your freedom? You're an American. Can a county take away your freedom? One that hasn't even bothered to enact a charter? And the answer is yes, if the law permits that. See how we got there? So the charter county can take away your freedom with the law that makes something a crime if the law permits that. Because you remember, the charter county can do anything that's not inconsistent, but the non-charter county can do anything the law says. So therefore, the non-charter county can take away your freedom by making something a crime if the law permits the non-charter county to do that. But now let's look at the other type of county. Can a charter county enact a law making something a crime? Can a charter county do that? And the answer is yes, unless a law forbids it. So compare. They both got the answer yes, did they not? But they got to yes in opposite ways. The non-charter county got to yes if the law permitted it. The charter county got to yes unless a law forbids this. And this is how I introduce you to the concept of home rule versus Dillon's rule. See how I'm getting there? Stay with me now. So under the plain text of Article 8 of Florida's Constitution, the non-charter government has such powers provided by law. The charter government has all powers not inconsistent with the law. Let's move on now from charter and non-charter counties. Let's talk about other municipal corporations. Are those the only type of municipalities that can be created under Florida's Constitution? No. Indeed, the state of Florida is divided into counties. Maps already drawn. Every mile, square mile, every hectare, every little morsel of Florida land resides in a county. There's no piece of Florida that's not in a county. And every square mile, every little bit of land is in exactly one county. So there's no uncountified, if that's a word, piece of land in Florida. But you know that there's more than just counties, right? I'm here in the city of Orlando. I'll be driving home to the city of Winter Park. Not that far apart, but they're both incorporated. In addition to a county, you can incorporate other municipalities. And you get to give those municipalities the name you want. You could call it the city of Winter Park, which is what my city is called. City of Orlando. It could be, instead of city, you could go with town. Instead of town, you could go with village. Indeed, there's a place here, not far from here, in Florida called The Villages. That's what they called their incorporation. I like to visit the Northeast. They have hamlets up there. I don't know of any hamlets in Florida, but I guess that would be another option. So you call it what you will, but it's less than a county. Under Florida's Constitution, there are requirements. A city, town, village, hamlet, if there is any, must be entirely within one county. You can't have the physical boundaries of a city, town, village, hamlet exceed the boundaries of that one county. Every piece of that city, town, village is all within one county. Now that can be awkward. I live in the city of Winter Park. We've got 32789 as one zip code, 32792 is another, and Seminole County has part of the 32792, and that part is also, for post office purposes, called Winter Park, just as the city of Winter Park is called Winter Park. So there's City of Winter Park 32792, and there's Winter Park 32792. Will we ever come together? Will we ever all be one big, happy Winter Park? And unfortunately, the answer is no, because part of Winter Park 32792 resides in Seminole County. And under Florida's Constitution, we can't unite. We'll forever be divided. I know, brings tears to your eyes, does it not? If it makes you feel any better, it's hard to tell when you're in Orange County or when you're in Seminole County. So we still got that feeling of community. But technically, we'll never be all part of the city of Winter Park. Ordinance versus resolution. As I mentioned, these subnational governments that are also sub-state governments, be they counties, cities, towns, villages, the villages, all have lawmaking power. They can do it. But we don't call these local laws statutes like we do for most laws that come out of the Florida legislature. Instead, we call them either an ordinance or a resolution. So these local laws made by municipalities, be they counties or other municipalities, are either an ordinance or a resolution. What's the difference? An ordinance is a regulation of a general and permanent nature and is enforceable as a local law. That's an ordinance. A resolution, on the other hand, is an expression concerning matters of administration or of a temporary character or disposition of administrative business. Resolutions typically begin with the phrase, "Be it resolved." So in practice, it can be easy to spot which one it was intended to be, but here's the kicker. If it needed to be an ordinance, but was instead passed as a resolution, that is a violation of Florida's Constitution, and that law is on its face unconstitutional under Florida's Constitution. So that's the relevance here. So you're advising the municipality. You're the county lawyer or the city lawyer, okay? We want to hire another city manager. To start the search, must we pass an ordinance? No. We can say, be it resolved, that we start the search for a city manager. Why is that? Because that is a disposition of administrative business. That's going to put into action a result, the hiring of a city manager. My kids are 11 and 8. They're getting a little bit old now. They didn't want to go last year, but we used to have a tradition. We would go to Park Avenue in Winter Park when the vice mayor, I guess this wasn't important enough for the mayor, the vice mayor would hold and declare that it was Daniel Tiger Day. Daniel Tiger is this fluffy tiger that's on PBS. It's derivative of Mr. Rogers' Neighborhood. And now the kids are a little too old, but they used to love Daniel Tiger. Do I need an ordinance to create Daniel Tiger Day? No. I can simply say, be it resolved that today is Daniel Tiger Day. Again, that would probably fall under a matter of administration. What if I want to create 3 days of very diligent mask wearing? Do I need an ordinance or a resolution? Since it's of temporary character, I probably would get away with the resolution. What if I want to take away your money? I'm going to raise taxes. Be it resolved that the tax rate is now higher. No, that's permanent. You've permanently taken away my money. Therefore, you needed an ordinance, not a resolution. We'll study White versus Town of Inglis, where they put up a fence. Unless you take it down, a fence is permanent, right? So the fact that they said, be it resolved that we need a fence, made that law unconstitutional, and the dirty, rotten fence ripper-downerer, if that's a word, could avoid the fine of having taken down that fence because the law, the resolution, was unconstitutional. Again, these introductory topics of Florida municipal law might not be the most complex topics you've encountered in your law school career, but if I'm underestimating any of them and they need greater explanation, please don't hesitate to let me know, and I will flesh them out in greater detail. Ordinance versus resolution. Ordinance is general, permanent. Resolution is administrative or temporary. If you needed one but used the other procedure, you've got a facially unconstitutional law because it violates Florida's Constitution. I alluded to earlier, home rule versus Dillon's rule. Did you read about it? We're on pages 267 through 269. Home rule versus Dillon's rule. What are we talking about there? Home rule describes the concept that Florida's charter counties, cities, towns, and villages have governmental, corporate, and proprietary powers unless expressly prohibited by federal law, Florida's Constitution, or the Florida legislature. Home rule is the source of authority to provide municipal services, perform municipal functions, own municipal property, and enact municipal laws unless provided otherwise by law. Dillon's rule describes the concept that a municipal corporation cannot enact a local law unless a law permits that corporation to do so. So how do we compare and contrast home rule and Dillon's rule? Well, both are a source of authority, are they not? They both provide lawmaking powers. Home rule, to paraphrase, says the county can make that law unless some other source says it's forbidden. Dillon's rule says the county can't make the law unless there's a source of authority for doing so. Have you heard these concepts before? Yes, my friends, you have. We looked at Article 8, Sections F and G of Florida's Constitution, remember? Home rule means a municipal corporation can enact a local law unless forbidden. Dillon's rule means a municipal corporation cannot enact a local law unless permitted. Which concept is reflected in Florida's Constitution? Both, right? What we found there, we can go back to that slide. Here it is, right? We see Dillon's rule and home rule, right? So Florida's Constitution, I think, if we're going to stick labels on things, is one of both home rule and Dillon's rule. Where do we see Dillon's rule? Is that F or is that G? That's F, right? Dillon's rule says if you have a law that gives the county authority for lawmaking, then the county can make law. That's Dillon's rule. That's F, is it not? Look at G. That's home rule, isn't it? Home rule says the county can make any law not inconsistent and not illegal to make. That's G. So then why does everyone say that Florida is a home rule state? And the answer is because of Florida's Municipal Home Rule Powers Act. Florida's Municipal Home Rule Powers Act attempts, I say attempts because we're going to look at some case law here, attempts to give home rule authority not only to charter counties, but also to non-charter counties. The reason I say attempts is because it's a statute. Since it's a statute, that's a source of authority. So what do the courts do? They look at the statute called the Home Rule Powers Act to see if it gave the county the power to do that. In other words, right? The county can do it if the law says it can do it. So we labeled the law home rule, but it's not quite the same. It's not an organic source of law like home rule is, if the source of the home rule is a statute, right? Getting a little dull with that, aren't we? Let's try to jazz it up a little bit. Let's take a look at some cases here. First up on our list, just recently added during the break, I stuck it in here. It's when I was preparing the lecture, I thought, oh, this one's a little too dull. And the next one's so much more fun. But I'll do what I can to make this one fun too, right? Okay. City of Winter Park versus Southern States Utilities. We're flashing back to 1989. City of Winter Park has authority to provide utilities to a certain geographic area. That can be a lucrative thing. If you're the utilities provider, who's your competition? I hear silence. That's the correct answer. Nobody, right? The provision of utilities looks a lot like a monopoly, does it not? And the reason it looks a lot like a monopoly is because it is a monopoly. Well, what about antitrust law? Well, we're not here to study federal antitrust law. That was my opening joke. So I'm not going to turn this into an antitrust class. Suffice it to say that federal antitrust law carves out an exemption and allows monopolies for utilities. Enough said. So, who's your competition? Nobody. This is lucrative to be the only provider. Southern States Utilities, Inc. is suing Winter Park because they'd like to be the provider. They got like the lamest argument in the world. Apparently, the people they are ready, willing, and able to immediately provide utilities to can't get utilities from the City of Winter Park because City of Winter Park isn't able to do it. 17 years from now, they'll be ready, City of Winter Park, to provide those utilities. And they're in Winter Park's exclusive area. So all Winter Park is asking these people without utilities to do is just wait the 17 years. They'll get the utilities. Stop listening to these Southern States Utilities people who want to turn on your utilities right now. You're in our exclusive Winter Park provider area. Shut up and wait. The outcome of the case is bizarre. It says, no, you don't have to shut up and wait. Didn't see that coming, did you? Yeah. No, the outcome of the case was that citizens do have some rights. And they certainly have some need for utilities. And that might be your exclusive area, but, 17 years until you can get to them, they have the right to hook up with Southern States Utilities now. That's the outcome of the case. Not a groundbreaking ruling. I almost left it out of the lecture. Let's look at notes and questions to consider. We are on paper page 279. If you're in the ebook, we're in chapter 9, subsection E as an egg. All right. 1, was the city of Winter Park's desire to be the utilities provider unreasonable in your opinion? Somebody think it was reasonable? Okay, we'll move on from that question. Number 2. Is there a number 2? Oh, there's no number 2. All right. Well, I can see why I cut the case out of the lecture in the first place. Sorry I added it in there. But now we get to one of my favorite cases of the semester. Allen's Creek. Love Allen's Creek. And you know me. Like you, I've only got the facts that you can find in the opinion. Unlike you, I've probably got a few more facts than you can find in the casebook opinion, because I did my best to diligently edit these cases, make them readable, make them digestible, make them contain the points of law they need to contain without you reading too much extraneous material. But you know, there's some facts that we're just never going to know because they're not in the publicly available opinions. And that's when I like to, if you don't mind, take a little poetic license. And with some poetic license now, allow me to give you some additional facts that might be part of the facts of the city of Allen's Creek. It was a dark, stormy day when the developer of Allen's Creek sat in the waiting room of the city manager of the city of Clearwater. In his hands were the blueprints for the beautiful Allen Creek development that he had already invested so much of his money and time into creating. He was going to create beautiful Allen's Creek with every modern amenity and luxury for the beautiful new homeowners who would buy those homes that he would build. He would make a great profit, and they would have a wonderful community. He wanted them to have all the modern conveniences, including the ability to flush the toilet. That's right. He wanted to hook up each and every town in Allen's Creek to the sewer system. Now, there are other options. You can have a drainage field. You can have a septic tank. But this developer, he wanted to hook up to the sewer system. And certainly a family has lived with a septic tank and has lived healthily and happily. But this developer thought sewers were right for Allen's Creek. And so he waited on that dark and stormy day in the waiting room of the city of Winter Park manager, till finally the dark door opened with a creak. And although it was dark inside, he could see some cigar smoke, and he could hear the city manager say, "Those guys can come in now." And he came with all the respect you would show to a city manager who was in a dark room with his feet up on the desk, with the window open, with a sign near the window that said "No smoking," and a big cigar in the city manager's mouth. Took another puff and blew the smoke in the direction of the developer. He tried to be polite and not cough. "I understand you guys would like our sewers," said the city manager. "Oh, yes, hi, yeah, no, I'm developing the Allen's Creek. It's going to be a beautiful community. I think sewers are right for our community. You're the exclusive provider of the area." "That is correct. I'm glad you guys understand that," says the city manager. Yeah, so what we'd like to do, we'd like to connect to the sewers." Yeah, you would like that, wouldn't you?" says the city manager as he drags another puff of smoke off the cigar. "And I guess that's why you have decided to voluntarily be annexed here into the city of Clearwater. Here's the form. You're going to sign that. Make sure you put the address for me to send the city tax bill to you and all the residents that you sell this to. And you will continue to pay City of Clearwater taxes forever and ever and ever. Oh, Mr. City Manager, no, maybe you heard me wrong. I'm not looking to become part of the City of Clearwater. I just need a sewer. Yeah. And you guys are in my exclusive sewer area. I'm ready, willing, and able to provide you with a sewer. So welcome to the City of Clearwater. Here, sign the form. No, we don't want to be in the City of Clearwater. Maybe you don't understand. I'm making you an offer you can't refuse. Welcome to the City of Clearwater. Well, this situation turns into some litigation. Apparently, Allen's Creek Properties Inc. feels some manipulations going on. Apparently, they feel it's unfair. You see, it's true the City of Clearwater is the exclusive sewer provider for the land of Allen's Creek Properties and where it resides. Now, we can't physically pick up that land and put it somewhere else. So it's always going to be within the City of Clearwater's exclusive area. Just like in the last case, where the land was in the exclusive area of the city Winter Park, this is in the exclusive utility service area of the City of Clearwater. Now, Clearwater is making it clear, if you want utilities, you will, quote unquote, voluntarily annex the land into the City of Clearwater. What will that result in? Tax revenue forever and ever and ever for the City of Clearwater. What's the ruling? The ruling is unique to Florida. Every other state that has encountered a similar situation has ruled the opposite. Florida's the only one. Their ruling is, welcome to the City of Clearwater. That's right. Supreme Court of Florida holds in Allen's Creek Properties versus City of Clearwater that if the municipal government has the exclusive right to provide utilities, and you want those utilities, then they can add conditions such as voluntarily, see my air quotes, voluntarily being annexed into the city. Welcome to the City of Clearwater. Fair? Somebody here come up with an argument for how that's fair? No other state that's looked at this fact or similar facts have come up with an argument for how that's fair.
How do the other states?
They all hold the opposite. You cannot add such conditions, such as requiring, quote unquote, voluntary annexation.
Provide the utility for free?
Well, no. You got to pay, you got to provide, you have to do the things that are part of hooking up to the sewer. You're going to have to pay to hook up the sewer line. You're going to have to pay for the sewer services. But you don't have to go over and beyond to unrelated things, such as surrendering your right to be in outside the city limits and voluntarily being annexed, if you can even call that voluntary.
But they still have to pay taxes on.
Well, they still got to pay for the sewage they use.
Okay, that's what.
But that's what they got to pay for.
Right. But
They still got to pay to hook up to the sewer, that initial hookup. But that's what they got to pay for. They don't, in addition, have to join the City of Clearwater and pay taxes and be annexed. Yes.
San Antonio, the city of San Antonio, it just keeps going around Howard.
I went to San Antonio once. It was a great town.
There's little pockets, there's like Leon Valley and there's China Grove, there's little cities that are actually 100% surrounded by San Antonio. But they chose not to. That's why my mind went screwed up when I was reading these things. Like, that doesn't make sense, but it's like I said, it's other states that.
So you know San Antonio better than I do. There's parts that are like landlocked. They're surrounded by incorporated city of San Antonio, but they themselves are not part of the incorporated city?
They were their own city before.
Okay.
San Antonio city limits.
Oh, I see. They found themselves surrounded
And then
over time through annexation.
They came up to it, they're like, okay, we'll try to give it, and the city said, nope. because the city, the sales taxes were different, like no weed.
Yeah.
And the
Well,
city-
I don't know. I didn't know those facts, but let's take those facts. Let's pretend that's Florida. Let's apply these two cases. Let's apply the holding from City of Winter Park and the holding from Allen Creek versus City of Clearwater. First, City of Winter Park. If they were these lands you're talking about within the exclusive provider zone, but the city was not able to provide, and another provider was ready, willing, and able to provide, then we know from City of Winter Park that doesn't matter they're in this exclusive City of Winter Park zone. They can sign up with the competitor, Southern Utilities. Rather unusual to have a competitor, but there was a competitor. So now let's say the city is ready, willing, and able. They just want more. They want more than just a lifetime of city usage, sewer usage revenue. They want more than just reimbursement for the initial hookup costs to the sewer. They also want this and that and the other things, such as welcome to the city. They will be voluntarily annexed within there. In Florida, and in Florida alone, the city as utility provider can exact those things, can force those things.
Is there a cap at any point that they can just ask for?
Not yet.
Form, like,
Not yet. You can just go without the sewer. You can have the septic.
yeah, but not in reality.
Hey, you know, I lived on a septic when I was a young man. It's
Right,
possible.
Probably not
It's
for
possible.
entire property. Like,
Oh,
entire
for
community.
yeah, if you wanna, depending on the perk, which is how much the land can absorb, trying to keep this clean. We're talking about sewage after all. You know, you can only have so many septic tanks within a certain geographic area. So yeah, maybe Allen's Creek was contemplating more houses than the perk would allow for septic tanks and drainage fields. So yeah, maybe as a practical matter, he had to give up some of the houses that he wanted to build if he was stuck with the sewer and drainage field. Stuck with the septic tank and drainage field rather than the sewer.
Maybe we should use that as a negotiation. It's like, okay, well, if you want us to not be on your plan here, not use the sewer, we'll discontinue the groundwater for you guys.
Make sure you guys are downhill.
You know, like, maybe litigation wasn't the right solution, huh? Those embellished facts of mine, maybe they should have went further. There should have been, some broken kneecaps or something. I don't know. But anyway, I should stick to the facts. So let me draw your attention to notes and questions to consider on paper on page 283. Notes and questions to consider for Allen's Creek versus City of Clearwater. The slang phrase "up a creek without a paddle" and its four-letter variants describes being in an awkward or unpleasant predicament without a ready means of resolution. In a Florida Bar Journal article titled "Up Allen's Creek Without a Paddle, Can Cities Leverage Utility Service for Annexation?" the author describes Allen's Creek as follows, quote, "Cities should beware because even 20 years after it was decided, Allen's Creek continues to raise questions about the legalities of municipalities compelling county property owners to annex into a city to obtain that city's utilities. Hailed as a victory for cities, the Florida Supreme Court's decision in Allen Creek held that cities can require landowners in unincorporated areas to execute, quote, voluntary, quote, annexation petitions in return for access to city utilities. But the decision brings up many troubling issues familiar to those in local government, such as judicial interference in the operation of local government, cities' ability to control growth on their borders through annexation, and the right to leverage annexation for utilities." End quote. That's Catherine Reichman's Up Allen's Creek Without a Paddle article from the Florida Bar Journal, the July-August 2016 issue. So do you agree with the quote you just heard? Do you agree that Allen's Creek creates an appropriate solution to these problems? Was Florida the one that got it right and the other 40 some odd states that ruled otherwise got it wrong? No, no, no. Nobody's wanting to be in that dark room, puffing on that cigar, holding all that power, huh? Lord Acton said, power corrupts. Absolute power corrupts absolutely. In a certain way, this is some absolute power that Clearwater has over Allen's Creek, isn't it? Yeah.
They didn't really argue any policy points either. It was just the law allows it.
The law allows it.
That's basically what it was. There's
The
no
law allows it.
should the law allow it.
Yeah.
Just the law allows it.
So when they held the law allows it, was this a home rule or a Dillon's rule type of ruling?
Home rule.
Yeah. Yeah. There wasn't a law that forbade it.
Yeah.
Therefore, it was allowed. Note 2. So the rule of Allen's Creek is that a Florida local government is not obliged to provide utility services, even within its exclusive area. Is that true? What about the ruling in City of Winter Park versus Southern Utilities? Can't that 1989 decision be interpreted to say that you are obliged to provide utilities within your exclusive area? The answer is no. You can reconcile these two cases. You can put together City of Winter Park versus utilities and put that together with Allen's Creek versus City of Clearwater. If nobody is able, not even you, to provide utilities within your exclusive area, then you run the risk that a competitor who is available might get your customers. But if it's available, you can do it for that area. You as the municipality have the right to say, nah, not for you. Nope, won't give it to you. Won't happen. That's how we put those two cases together. And that's only in Florida. You're not going to find that outcome under any other state constitution except Florida's constitution.
And then if we look at the Winter Park case,
Yeah.
what is the cutoff? Like 17 years is too long, but is 5 years too long?
Well, you raise a good point. We don't have either in the ruling or the dicta how long is too long.
Right.
One might argue that City of Winter Park can be interpreted to put your customer base at risk anytime you've got an exclusive area but an inability to provide service to that area. And that's probably the best way to interpret that case, because in so doing, we're protecting the interests of the citizenry, are we not? What we're saying to the citizenry is 17 years, 17 months, 17 weeks, you deserve utilities. That's what we're saying in City of Winter Park versus Southern. But in a way, we're saying the opposite in Allen's Creek versus City of Clearwater. We're saying we're not worried about the rights of the citizenry. The municipal corporation has rights. The City of Clearwater has rights. It's their exclusive area. As long as they're able to provide services throughout their exclusive area, if they don't want to provide services in that area, then there are no services in that area.
So did they already have sewage lines running through Allen's Creek property?
No, that's what they wanted.
Right. So
In Allen's Creek, they
couldn't
wanted
do
the
it
sewer
immediately
lines.
then.
And the City of Clearwater said, yeah, you could have them as soon as you voluntarily annex into our city.
Well, it would take time, right? They would have to lay the pipe, they would have to build the sewage lines, they would have to do all.
I love your argument. You're trying to use Winter Park to get a different outcome in Allen's
Right.
Creek. But Winter Park predates Allen's Creek. That precedent was already on the books. And Allen's Creek had this outcome anyway. Yeah. So I think the best way to put the two together is to say this: if it's an exclusive utility area, but the exclusive provider can't provide, then that area has a chance at getting another provider. But if it's an exclusive area provider and that provider can provide, then those people in that area run the risk of not getting services if the exclusive provider doesn't want to provide them. And to make them want or not want to provide them, the exclusive provider, being a municipality, can impose exactions, can impose a price, can impose even unrelated things such as being annexed into the city before you can have those utilities. That's not an outcome you see under any other state constitution other than the Constitution of the state of Florida. So that returns me to my ongoing theme of trying to teach this class with reference to what you already know about constitutional law and highlighting the differences. Any other questions about chapter 9? So in a way, we've covered 2 chapters today, so that's nice. That helps us with our syllabus problem of where we've got to cover 3 chapters in 2 classes. So since we covered 2 chapters in this class, now we can go back, hopefully, and stick to our original plan. Every lecture, we'll cover 1 chapter. In our next lecture, we will talk about legislative power. That's chapter 10. I hopefully will finish that in a 2-hour stretch. It's a possibility that that might spill over into the next lecture after that. But if it does, we'll still cover and finish chapter 11, executive power. 2 lectures from now, 3 lectures from now, we'll be doing chapter 12, which is judicial power. So for next week, be on the ready for chapter 10. Probably the week after that, be on the ready for chapter 11, although you might need to be on the ready to finish chapter 10 and then cover all of chapter 11. And that's how we will continue to proceed. Any questions about that? There's a question. Yeah.
Are we going to have any time to go over the midterm?
Oh, okay. So that's you. How can I help? What would you like?
I was kind of, I was wondering, are we going to have a review so we can see where, like, so there's all, let's find out how we did or how we didn't do.
Okay. So you're not obviously not asking about the midterm grade because those were already provided. You're asking for
Like, for feedback for how, like, just reviewing the questions, where that's not, it's not an option.
no. I'm here to serve. I just want to know how best to serve. So tell me what you'd like to see me do.
Well, we just have to grade on it.
Yeah, you took the midterm and you got a grade. I'm here to serve. I can do more. Tell me what it is you'd like to see me do. If you want to think about it, I'm not trying to put you on the spot. And it's a question open to anyone, so I'm not trying to put everyone on the spot. But if you want to get back to me next class, let me know what it is you're asking me to do. I'm here to serve. I'll do it.
Well, we have no way to see how we did, where we did well or how we did.
Oh, I hear you, and I'll help. I just want to know. I guess I want to know collectively as a group what you want. So I don't need to hear it right now. If you all want to talk amongst yourselves quite literally and then get back to me when we meet next week. But I'm here to serve. If you need me to do something, I'll do it. So, yeah.
I have a question. Do you have any idea what our final will look like?
Oh, it'll be brutal. Yeah. But it'll look like the midterm.
It'll be more.
As I understand, I'm required to give you a multiple choice test. If it's up to me, there'd be no multiple choice questions at all. I like essay exams, especially in law school. But that's all right. You know, I'm a believer in subsidiarity. If somebody with authority over me says that multiple choice is best here at this law school at this time in this class, then so be it. Maybe it's a COVID thing. Maybe it's something else. I respect their authority. That's what I'll do. So yeah, you'll see another multiple choice exam. And I suspect it'll be at the same level as the midterm was. What'd you think of the midterm? Did you consider it basic? Did you consider it mid-level? Did you consider it advanced? Where do you think it was? What's your opinion of it? Not too bad? Okay. All right. I like to think that I test on what I teach and that I teach what I test. And maybe a true academic would take issue with that, like a teacher shouldn't teach to the test. And I don't criticize that. It's just in my own instance, I wrote the book and I wrote the syllabus, of course, and I wrote the case book, and then I wrote the lecture about my case book. It would just seem really disingenuous for someone to write the syllabus and the case book and the lecture and then test on something else, right? So there's a time and a place for the teacher shouldn't teach to the test, but If you're standing in front of the teacher who wrote the book, shouldn't he be testing on what he wrote, right? You know, so I'd like to think that I test what I teach and teach what I test. Is that your experience? Do you believe what you saw in the midterm were things that I taught? I'm seeing nodding heads. I really want to see nodding heads. I'm hoping that's true. If that's not true, I welcome your feedback because that's my goal. I want to test you on what I taught. So, yeah.
I was looking at previous classes on your website, and for one of them, for the essay, you had a prompt associated with it, like a fact pattern and what have you. Are we gonna have that as well for our essay, or is ours just gonna be?
If it were up to me, it would be an essay exam. It's not up to me. It's a multiple choice exam.
No,
So-
not the final exam, the subsidiarity essay that we have.
Oh yeah.
Are we gonna have a prompt similar to the one that's on your website, or
Well,
are we gonna have?
You know, what we've got is a far more open-ended than when we had that last semester. So you've got I'm taking from the syllabus, the last page 6. So this is going to be due 6:30 p.m. on the day that our last lecture occurs, which if it goes as scheduled is going to be on April 22nd.
Right.
So unless, hurricanes happen, COVID happens, unless something happens, it's going to be due 6:30 p.m. on that day, which so far is going to be April 22nd. So it's a 1,000-word essay. The topic is subsidiarity, but you get to pick the specifics of that. So it's got to be a topic we covered in class, which is very open. It's a survey class. There's a lot of topics in the book here. Sometimes the book literally talks about subsidiarity. If you've got the paper version, it's got an index in the back, and you can look up subsidiarity. And I don't know that it's complete, but it certainly gives some of the references to where the case book I wrote literally talks about subsidiarity. Subsidiarity. Pages 3 through 4 is all that's cited. I know that talked about more than once.
Right. I just
Yeah.
think the prompt you had online was also about subsidiarity.
Yeah. So if you like that topic,
Are we doing another
and
one?
we're talking about the class website, flaconstitution.com. So anyone can look at it, and if you like that topic, you can make that your topic.
Right.
And you can talk to me about subsidiarity. So what I'm looking for you to do is to write about how the doctrine of subsidiarity arises in the context of your chosen subnational constitutional law topic. So, I remember another time the book explicitly mentioned the word subsidiarity. We were talking about sexting when we talked about the right to privacy. Remember that? And I quoted from a law review article from somebody from Ave Maria Law Review, talked about subsidiarity as a solution for the problem of sexting. So there's another instance where the book literally talks about subsidiarity. But that theme, I think, runs through the book. It certainly comes up in my lectures. So where you see an opportunity to talk about it, where you'd enjoy writing a 1,000-word essay, then grab that. Make that your topic. I would enjoy hearing about it. Maybe you're a proponent of subsidiarity. Maybe you're an opponent of subsidiarity. I'm not going to grade you on whether you're right or you're wrong. I'm going to instead grade you on the depth of your analysis. So at the end of reading your essay, maybe I'll just utterly disagree with it. But if it was beautifully written and there was insight and there was analysis of how subsidiarity arises or should arise or should not arise on that particular subnational constitutional law topic, I might give you a perfect score, even if ultimately I don't agree with your outcome or your conclusion. It's not about right or wrong. It's about being a lawyer. It's about taking a position and arguing that side. Because whether you're a negotiator, taking a position and arguing a side, or you're a litigator in front of a judge, trying to convince that judge of your position and your client's side, that's part of lawyering, right? Even if you're in transactional law, you're trying to get the transaction to smoothly go through. You're trying to argue that it's correct. That's what lawyers do. We take the facts as we find them. Sometimes we have to go find them, but then we take the facts as we find them and we apply the correct law and we argue for a particular outcome. So do that in your essay, and that's what will get you the perfect grade, regardless of whether I agree with your point or not. Yeah. Make sense?
Yes, sir.
All right. So please talk among yourselves, whether it's 1 or 2 or 36 of you talking among yourselves, and let me know if there's something I can do to help you better understand why the correct answers on the midterm were the correct answers. Be specific as to what you want me to provide. I'm here to serve, and I'll provide it. All right. Well, that's all I've got for today. You know our procedures from here on out. And until we meet again, may God continue to bless us all. Thanks for taking my class. Thanks for putting up with me. And you all at home, thank you. Bye now.